record, we're in Botana County District Court. My name is Anthony Swain Benson. I am the District Court Judge. It's been assigned to handle matters here in Botana County. Our next appearance today is in case 05-2019 CV85. This is an action in Botana County. The caption of the action, I'm just waiting for the complaint to pull up on my computer, is Northwest Landowners Association versus the State of North Dakota Industrial Commission. Was the Board of University and School Lands of the State of North Dakota, but they have since been dismissed. The Honorable Douglas Burgum in his official capacity as Governor of the State of North Dakota. The Honorable Wayne Stenjum in his official capacity as Attorney General of North Dakota as defendants. And then also the issue today is a motion to intervene by Continental Resources. So they have filed a motion to intervene. I do note that we are conducting this hearing by remote means, given the current state of the COVID-19 pandemic and its effect it's had on life in general as well as the court operations. I think virtually all of the courthouses in North Dakota have closed to the public because of concerns about mitigating disease throughout the society. However, we are still carrying on. We are doing so in a remote capacity. So the hearing today is going to be held by teleconference. I have a number of people that have called in to the phone line, and so I've been keeping track of the individuals here, and so let me just go through and I'll have everybody identify themselves, and if you can just indicate your capacity, who you represent, and then where you're located. If anybody is with you there, I would appreciate it. And I'm going to start with Mr. Legate. If you could identify yourself and provide that information, please.
Thank you, Your Honor. My name is Poe Leggett, representing applicant for intervention, Continental Resources, Inc.
Okay, thank you. And then I believe Mr. Alex Obrecht also appeared on behalf of Continental. If you'd do this, provide the same information.
Yeah, thank you, Your Honor. Alex Obrecht with the law firm of Baker and Hostetler, representing the applicant for intervention, Continental Resources. Currently taking this call from Denver, from my home. My two children and wife are in the house, although not in the office with me. Thank you.
All right, very good. Thank you. And then on behalf of Northwest Landowners, I believe we have Mr. Broughton, if you'd provide the same information.
Sure, Your Honor. Derek Broughton with Broughton Law Firm on behalf of Northwest Landowners Association. I am at my home office as well, but there's no one in the room with me.
All right, thank you. And then Mr. England, please.
Thank you, Your Honor. J.J. England, appearing on behalf of Plaintiffs Northwest Landowners Association, and I am by myself in Minneapolis, Minnesota.
All right, very good. Thank you. And then on behalf of the defendant state, I guess Ms. Meyer, if you'd provide that information.
Yes, Nikki Meyer. I'm an Assistant Attorney General with the Attorney General's Office representing the state defendants. I'm in my home in rural Mandan, North Dakota. My son is in another room in the house. Nobody else is here with me.
All right, thank you. And then Mr. Sagsveen.
This is Matt Sagsveen on behalf of the defendants. I'm an Assistant Attorney General, Solicitor General with the State of North Dakota Office of Attorney General, and I am also at home and homeschooling at the same time.
Fair enough. All right. Thank you, Mr. Sagsveen. And then Ms. Samuelson, if you'd identify.
Ashley Samuelson. I'm a law clerk with the Northeast Judicial District. I'm located at my home in Devil's Lake, and there's nobody else here in the room with me.
All right. Thank you. And then I believe it's Ms. Shelton. You're also appearing. Could you just identify yourself and indicate your capacity here?
Yes, Your Honor. This is Amy Shelton. I'm the Executive Director of the Northwest Landowners Association, and I'm calling in from my home in Houston, Texas, and I do have my children and husband in the house with me, but not in my office.
All right, thank you. And let me just open it up, I guess, first for the attorneys for counsel. I have been reviewing the documents here, and just shortly before the hearing, I decided to look at some of the correspondence regarding this hearing and notices, and I did note that I do have a couple of different conference call numbers I use, but there may have been a little confusion. I think we have everybody on this line, but I'm just going to go through briefly check first on behalf of Continental, Mr. Leggett or Mr. Obrecht. Is there anybody else you're expecting to call in here regarding this hearing today? Anybody we're missing?
No, Your Honor.
Okay. And then Mr. Broughton or Mr. England, on behalf of Northwest Landowners, is there anybody else you're expecting to call in?
We were expecting Troy Coons, the president of the association, to be calling in, so I will try and get in touch with him quick and make sure he has the right number.
Okay, and that's why I want to make sure that everybody's got the right number. Other than Mr. Coons, was there anybody else that you were expecting?
No, and I think I did just hear him. He's on.
Okay, is there Troy Coons? Are you on the line as well?
Yeah. Yes, Your Honor, I am on the line. As chairman of the Northwest Landowners Association, I am at home in my home office with nobody else in the office as well. Thank you.
All right, thank you very much. And I'll just check one last time then, Mr. Broughton or Mr. England, that's all you're expecting to call in, that you're anticipating at this point. Is that what I understand?
That's right, Your Honor.
Okay, and then just check with Ms. Meyer, Mr. Sagsveen, anybody else you're expecting to call in?
No, Your Honor. Everybody that we expected is on the line.
All right, very good. And I do note, so I apologize for the late confusion on that, but it appears we have everybody on here, and I do note that I did sign an order stemming from an unopposed motion to allow the recording of this by Ms. Shelton and the sharing of this with the public and Northwest Landowners. And so with regard to that, then, I do note for the purposes of the hearing today that on January 10th of this year, there was a motion filed by Continental Resources seeking intervention. Along with the motion and brief were a couple of exhibits. Thereafter, on the 24th of January, there was a brief opposing the motion to intervene filed by Northwest Landowners and their attorneys. And then finally, on January 31st of this year, a reply brief was filed, again in support of the motion to intervene. So that is the issue that we're discussing today. So with regard to that, then, I will turn it over to Mr. Leggett, if you are going to be offering the oral argument. The floor is now yours.
Thank you, Your Honor. May it please the Court. I am Poe Leggett. To help manage everyone's expectations, especially since most on the phone have children in another room, I anticipate talking, subject to the Court's questions, of course, for about 12 minutes, and then if the Court would allow me about 3 minutes for rebuttal after Mr. Broughton has spoken. Continental is one of the largest producers of oil in North Dakota. It is only able to produce this oil by having secure title to the pore space in the underground formations it has leased. Continental has bought the rights to use the pore space for oil and gas purposes from landowners. Some are members of the Plaintiff Association. In its complaint, the association has highlighted one of its members, the Fisher family from Bowman County, in 16 paragraphs of specific allegations against Continental. Because of the facts in these allegations, the association agrees, at page 3 of its brief, that Continental does have an interest in the subject of this lawsuit, which might be impaired by its outcome. The association still opposes our intervention, however. The association believes that the state of North Dakota adequately represents Continental's interests here. This is incorrect. Continental's interest is in defending its property rights and its ability to develop its oil prudently. The state is not interested in protecting Continental's property rights. Let me illustrate. Continental has more at stake here than just the Fishers, but I'll use their dispute as an example. Continental and its predecessors have been producing oil from underneath the Fisher surface since at least the 1990s. Continental paid the Fishers' predecessors to lease the right to use the pore space for oil development. Continental's right is recognized as real property under North Dakota law. But in 2009, the state of North Dakota passed a law that, in the association's view, gives the Fishers, by statute, ownership over pore space Continental already bought from the Fishers' predecessors long before 2009. The association claims Continental must pay the Fishers again to use pore space rights Continental already bought. And the whole gravamen of this case is that the state cannot take that statutory claim away. Now, will the state explain all of this to the court? That is highly unlikely. It is not the state's job to brief Continental's rights. We ask the court to recognize Continental's rights to make the argument for itself. Our interest in seeing the statute upheld is different from the state's. We fight for a law that upholds our property right. After all, if the state can hand Continental's right over to the Fishers by statute in 2009, then the state has the same constitutional power in 2019 to amend the 2009 law to stop taking Continental's rights away. But the test for whether the state adequately represents Continental is not whether we're making different legal argument. It is whether the state represents our particular interest. Continental's interest in not paying twice for the same right differs from the state's interest in promoting the welfare of the people of North Dakota. Remember, please, this is the same state that the association says gave the Fishers our real property right 11 years ago. And because of that 2009 law, the Fishers and Continental are still in a dispute. The state is not a party to that dispute. The state's interest does not coincide with Continental's. Your Honor, the rule of law is stated in a case cited in the briefs called Chiglo versus City of Preston. For the court's convenience, volume 104, F3rd, at 187 to 88. And I'll quote, "The government only represents the citizen to the extent his interests coincide with the public interest. If the citizen stands to gain or lose from the litigation in a way different from the public at large, the parens patria would not be expected to represent him." In applying this rule, two cases guide the court here. First is National Parks Conservation Association, cited on page 11 of our opening brief. There, a power company tried to intervene on the side of the federal EPA. Trial court denied intervention for the same reasons argued by the association here. The appeals court reversed. The power company, and here I quote the court, "Its interest in the litigation is more than mere procedural formality. It owns the target power plant. It is seeking to protect a more narrow and parochial financial interest not shared by the general public. The EPA is ultimately tasked with the much broader responsibility of executing the Clean Air Act's goals." 759 F3rd at 977. Continental is just like the power company. The state's broader interest here is like the EPA's broader interest. The second case is Mausolf versus Babbitt, 85 F3rd at 1303. There, an environmental group wanted the Interior Department to restrict snowmobiling in a national park. Interior previously allowed snowmobiling. Then Interior changed course, the snowmobilers sued, the group moved to intervene. The Eighth Circuit held that the environmental group had shown the government had not always represented its interest against the snowmobilers. Therefore, the U.S. did not adequately represent the group's narrower interest. The court held the group had a right to intervene under Rule 24 on the government side of the case. Groups and the government's interests did not coincide, just like here. Your Honor, we've cited several other cases in our briefs. I'll instead jump ahead to say that the Stenjum case, on which the association relies on page 6 of its opposition, helps Continental, not the association. There, the state sued the United States over rights to easements running along section lines, Forest Service grasslands. The United States denied there were any easements. The Sierra Club tried to intervene on the side of the U.S. club claimed an interest in having the U.S. promote environmental interests in the grasslands. The Eighth Circuit affirmed denial of intervention. It held that the underlying suit was not about how to manage federal grasslands. It was about whether section lines in the grasslands were federal at all. The court held the Sierra Club did not have any interest different from the U.S. on the issue of federal ownership. Here, in contrast, the state has no interest in Continental's ownership of rights to use pore space Continental has already paid for. Our interest, again, is in upholding the new statute honoring those rights. On the question of permissive intervention, the association objects that Continental took too long to file. The law took effect August 1. Continental sought the association's position on intervening in December of last year. The association has not filed anything in the case since the complaint other than its opposition to Continental's motion. Under Rule of Civil Procedure 16B1A, this court is to hold a case management conference. As the court knows, no party has yet asked the court to schedule that conference. No case cited to the court has denied a party intervention this early in the case simply on the ground that the intervener was too slow. The association next objects that delay may occur if Continental challenges the association's standing to sue. The state might challenge standing. So might this court, because standing is jurisdictional in the state. North Dakota Supreme Court has said so in Rebel versus Nodak Mutual Insurance, 585 Northwest 2nd at 813. Keeping Continental out does not keep the issue of standing from coming up. The association also objects that if the court lets Continental in, then Katie bar the door. The court will have to let every oil company in. Well, right now, no one else is knocking for admission, and the court would be well within its discretion to deny further intervention after all this time. And the association has given Continental special attention, devoting almost 10% of its complaint to allegations about Continental. That sets Continental apart. Finally, Your Honor, I ask you to consider a very practical point. In all the cases cited in the briefs, no trial court was overturned on appeal for allowing intervention. I do not know why the association is willing to risk having a possible victory before you overturned later because Continental was improperly denied intervention. It is a matter for the court to consider. If the court has no questions, I'd like to reserve a few minutes for rebuttal.
That's fine. I've got a couple of questions, just I think more citations and just a factual question. First of all, I lost the site on when you were talking about the case involving the snowmobile. It was 85 F 3rd, and I think you said 1303. That was the secondary site from the first site you had given me was on page 11 of your brief. The National Parks Conservation 959 F 3rd 977. You cited another case, 85 F 3rd, and I just missed the page, so I wanted to make sure I had that correct. What was that site, Mr. Leggett?
1303.
1303. All right, thank you. And then in that same vein, you would, in talking about standing being jurisdictional, I didn't, as I reviewed your opening brief and then your reply brief, what was the site on that? 585 Northwest 2nd, but what was the site on? I don't recall seeing that case captioned in the brief, so I want to make sure I've got that site correct as well.
585 Northwest 2nd, 811 at 813.
Okay, thank you. And then just the last question I have, the case involving the Sierra Club with the U.S. government, the Stenjum case, essentially, where the decision was that the Sierra Club interest was the same as the government's. Am I correct in understanding that when the Sierra Club was trying to intervene, it was for aesthetic and more policy purposes? Was there any pecuniary aspect attributable to the Sierra Club in their seeking to intervene in that matter?
There was none, meaning, to give a little more detail, they did not claim any ownership interest deriving from the government. They did not claim any pecuniary interest. It was just the general aesthetic and environmental interest in keeping grasslands wild.
Okay. Thank you. Those were just the questions that had come up as you went through your presentation. So certainly I will give some time for rebuttal argument. With regard to that then, I guess, Mr. Broughton, would you be arguing on behalf of Northwest Landowners?
Yes, I am, Your Honor.
All right, then I will turn it over to you.
Okay, thank you, Your Honor. I'd like to quickly address a few points made by Mr. Leggett before I get into what I think is really the crux of the issue, which is the purported interest that Continental seeks to protect. But first, just a couple miscellaneous points I think are important to respond to. One thing Mr. Leggett said is that the association has filed nothing since the complaint up until their opposition to the motion to intervene, which is not true. The association actually conferred with, came to an agreement with the state of North Dakota, dismissed an entire party from the lawsuit in order to streamline the case and prevent the addition of additional attorneys by the state to represent the Department of Trust Lands. So that is also something that was filed prior to the intervention opposition. With respect to whether the court or the state can bring up standing, I certainly agree that it's a jurisdictional issue. However, the state did not plead that as a defense. I'll get into that in a little bit. Mr. Leggett also says that the court could deny further intervention. I will also discuss this, but I would note briefly that if the court rules that Continental can intervene as of right, I don't think that's the case. I think the court could not, therefore, deny similarly situated oil and gas operators if that were the basis for granting intervention. And the other thing that Mr. Leggett said is that all of the courts that have ruled that intervention was properly denied were not overturned. Well, there were also a number of cases cited where courts have said that the appellate court said intervention should not have been denied, but in several of those cases, they also go on to say, but it was harmless error because those interveners submitted amicus briefs or were otherwise involved. And so I would note that as well. But what I really want to talk about, and what I think all of the arguments in case law really come down to, is an identification of and discussion of the specific property and business interests that Continental claims it's seeking to protect here. And some of these interests, at least the references to financial interests, are not the kind of interests that are discussed in the case law and by the courts. And what I'm getting at is just making vague references to a business interest or a property interest, or the fact that Continental has economic interest that might be impacted, is not enough, and those are not the kind of or specific particularized interests that courts look at when they're looking into intervention. The courts look at is the discrete cognizable interest at issue in this litigation. So the fact that Continental might have some financial impact depending on how this lawsuit goes doesn't automatically give them the right to intervene. We need to look at the discrete cognizable interest in this litigation, and that is Continental's obligation to pay surface owners for use of their pore space. And that's important because that's precisely why the Legislative Assembly passed this law. It's the purpose of the law, and it's the effect of the law, and that is exactly what Continental is concerned with. And so these other concerns about general economic interests don't don't cut it, and it's under the Fisher case, 546 Northwest 2nd 354, cited by the parties. They explain that a direct interest is one that is not remote or contingent. A legally protectable interest is one that the substantive law recognizes as belonging to or being owned by the applicant, and a party who qualifies as a real party in interest under Rule 17A is a party with a legally protectable interest. And so my point is we need to look at these specific interests, not just the fact that Continental might claim that there's going to be some economic impact depending on how this lawsuit comes out. So it's not to say that Continental does not have any interests that are at issue both in this proceeding and in this motion. We agree that whether or not Continental and other oil and gas operators have to pay surface owners for use of their pore space is precisely at issue here. That is the crux of the law that was passed, and that is Continental's interest. But what's significant about that is that Continental's interest in paying or not paying surface owners for use of their pore space is no different than any other oil and gas operator in the state of North Dakota. And so, as Mr. Leggett noted, we do have a significant concern here specifically because Continental's right or Continental's interest in not paying surface owners is exactly the same as any other oil and gas operator in the state of North Dakota, and there are dozens, if not more, oil and gas operators. And if this court were to grant Continental intervention as of right, that same logic and all the arguments made by Continental would apply to every other oil and gas operator in the state. And that would make this litigation unwieldy and almost impossible to be prosecuted by a small organization like Northwest Landowners Association. The other thing I would point out is, although Northwest Landowners believes that this is a frivolous request, both the state and Continental Resources claim that they are entitled to their attorney's fees if they prevail in this litigation. Now, obviously, Northwest Landowners doesn't think they're going to prevail, but should that happen, and should they have some basis for making that claim in their pleading, now on top of bringing this litigation to argue about the constitutionality of this law, Northwest Landowners put resources into that. Now the state is claiming that on top of the taxes, they need to pay the state for the state's attorney's fees for defending the law. And now on top of that, Continental Resources wants a small nonprofit organization in North Dakota to pay for their attorney's fees to defend a law that's already being defended by the state's attorney general. That's an unfair burden to place on the Northwest Landowners Association. So the main point I want to make about this, however, is that, as I indicated, the interest we're talking about that is being defended by the Attorney General and by the state of North Dakota is the desire and the policy decision to excuse operators to alleviate their requirement to pay surface owners for use of their pore space. And that's precisely what Continental wants to do here. And that's precisely what's already being done. I'd like to talk about a few of the cases cited by Continental because I think they illustrate the difference between Continental's interest in this litigation and how that relates to the parents patriae and to the state defending this law and some of these other cases cited. So one case is the Wild Earth Guardians versus National Park Service, and that's 604 F 3rd 1192. It's a 10th Circuit case. I'd like to point out first that the 10th Circuit actually didn't even address this prong of the analysis. It didn't come to a conclusion on whether or not the National Park Service represented the putative intervener. It remanded that decision to the district court because the district court hadn't made a decision on that issue. There is dicta, however, which is what was cited by Continental in its briefing. And I think it's important to look at the interest of the putative intervener in that case. What was being discussed there is Wild Earth Guardians had brought a lawsuit over concerns over how the national park area was being managed for the elk herd and whether or not it should be reintroducing gray wolves. Safari Club, a hunting organization, intervened or tried to intervene, claiming that some of its members were applying to be the volunteers to cull the elk herd under one of three different regulatory plans being put in place by the National Park Service, and the one that the Park Service had chosen had this provision that allowed for these volunteers to sign up and essentially hunt to help cull the elk herd. And so in that context, you need to understand that Safari Club, the putative intervener there, had a very specific interest in the litigation. They literally had members who they were claiming wanted to be a part of this program to help cull the elk herd. That's a very different scenario than here, where you have something very simple. Do surface owners need to be compensated for use of their pore space? If SB 2344 and the laws that were enacted thereby stands, no, they don't. And it's really a binary decision here. And because of that, the issue here is simple. Continental's interest is perfectly aligned with what the state is doing, which is defending the constitutionality of the law. Another example is the Dimmond v. District of Columbia case, 792 F. 2nd 179. Continental cites to and quotes a couple paragraphs from pages 192 to 193 of the decision, but they fail to quote the very next paragraph, which provides some very significant and important context to what comes before it. And this case had to do with District of Columbia insurance regulations that had been passed, and State Farm, an insurance company, had attempted to intervene because they had set specific rates based on the law as it stood, and were concerned that because of the possible retroactive application of a decision by the court, it could result in those rates being essentially inappropriate or causing a shortfall for them. And so the very specific rates they set for the District of Columbia were at issue for them. What the court then went on to say after the paragraphs quoted by Continental in its brief is, this is not a case where, despite the difference in the interests of State Farm and the district's representation of the general public interest would nonetheless lead the district to make the same legal arguments that State Farm would make. And what they say is State Farm's principal concern involves the severability of Section 6B6 and the retroactive application of any decision by this court or the district court invalidating that section. And so the point being made by the court here is that the results State Farm urges are not necessarily those that the district would advance as in the public interest. So going back to this case, it's much simpler. There's not an argument being made that Continental wants Section 6B6 to be severed and to not have retroactive application as to that, because that will affect certain policies passed by Continental with respect to its operation of a unit. What we're talking about is surface owners own the pore space, always have. Do they need to be compensated for the use of the pore space? Yes or no? The state says yes, state says no. Northwest landowners say yes, they need to be compensated. Continental joins the state saying no, they don't. That's as simple as the interests are involved here that need to be considered for purposes of intervention. So the final case I want to address, similar to the others, helps illustrate the difference between this case and these other cases being cited by Continental. It's the Planned Parenthood of Minnesota case versus Citizens for Community Action. It's an 8th Circuit case, 558 F. 2nd 861. And there's just a couple quotes that, again, highlight the difference between the very particular and detailed interests that interveners were attempting to protect in these other cases versus the very generalized interest that Continental wants to protect in this case. And so in the Planned Parenthood case, there were zoning regulations that potentially barred any abortion facilities from being zoned in certain communities. And the court noted that the application for intervention from a community organization was joined by two couples, Donald and Mary Ann Lennon, Norman and Kathleen Vernig, who owned property in the vicinity of the proposed Ford Parkway abortion facility. The Lennons and the Vernigs wish to intervene to assure that their property values are not adversely affected by the creation of that abortion clinic in their neighborhood. So we're talking about very specific people with property with a proposed abortion clinic going into their neighborhood right next to them, it's going to affect their property values. That's a very specific and particularized interest in that litigation that they're seeking to protect. That's very different than the very binary and generalized decision or issue that Continental seeks here. And the court there explained that, both applicants and defendants are interested in upholding the constitutionality of the ordinance. However, their respective interests, while not adverse, are disparate. And the other thing they pointed out in that case is that the defendants, the government, was accused of invidiously discriminating against Planned Parenthood in particular and abortion clinics in general. Allegations of bad faith have been directed against the defendants. Many of the defendants are seeking to avoid personal liability for allegedly infringing on Planned Parenthood's constitutional rights. And so again, you have a situation where, yes, the governing body is defending a statute, but not necessarily defending the rights of these other individuals, specifically because these other individuals have a specific property interest they're trying to protect, as well as because the state is also in a position where it's trying to also protect certain members of the governing body from personal liability. And so I wanted to point out these cases because I think they illustrate the difference, again, between a lot of the cases being cited by Continental in its brief and what's really at issue here, which there are a number of different provisions that were enacted as a result of SB 2344. However, the law as it stands together was enacted for one purpose, and it was enacted to take away the ability of a surface owner to obtain compensation for use of their pore space by oil and gas operators in North Dakota. That was, and this is important, that was the reason the law was passed, that was the purpose of the law, and that is the effect of the law. That is what the state is defending, and that is what Continental is trying to protect by intervening here. So I also want to go back to Continental's statements about the standing defense they've asserted. And they state that, well, the judge obviously and the court have to look at standing because it's a jurisdictional issue if they take it up. But they don't if there's no reasonable basis to challenge standing, and based on the allegations in the complaint right now, there are not. However, that does not prevent Continental from conducting an invasive and searching discovery process in order to challenge that, and whether Northwest Landowners thinks that that is a frivolous defense or frivolous claim isn't going to bar them from conducting that discovery and significantly driving up the expense of litigation for no reason in our view, because this is a facial challenge to the constitutionality of a statute. And the Northwest Landowners clearly has standing. There's probably no organization that would have greater standing than the Northwest Landowners Association. But it is nonetheless a small nonprofit association built by landowners in North Dakota, and to have to go up against, as Continental puts it, one of the largest independent oil and gas producers in the state and have thorough searching discovery conducted on them for that purpose is daunting, expensive, and unnecessary. So I want to go back to my fundamental point, though, and it's what I just said, which is that, first off, we disagree with Continental about whether or not the floodgates are going to open. It very well could open the floodgates, and if the court rules that Continental should be granted intervention as of right, I don't believe the court is going to be able to deny intervention to similarly situated oil and gas operators in North Dakota. And it's true that they have not really the court's discretion. And because it's the court's discretion, I'm not arguing that it would be illegal and impossible for the court to allow permissive intervention. What we're arguing is that it's unnecessary and burdensome to Northwest landowners in a way that is compelling enough to deny that intervention. And the final reason is because, as I have said repeatedly, you really need to look at what specifically Continental is trying to protect here. They're trying to protect their new right, their ability to not pay for use of the pore space. Again, That's what the law does. That was the purpose, and that's the effect. By defending that law, the state is perfectly representing Continental's interest. And there's nothing that Continental is going to do here other than invasive discovery that is going to add to what the state is doing. So with that, Your Honor, I don't have anything further unless the court has questions.
Just a couple questions, I think. First of all, as to one of the last points you made, the intervention as of right as compared to the permissive intervention. Obviously, there are different standards to be applied in those situations. The question occurs to me, and this is a bit hypothetical looking in the future, but is there a difference? Do you think there is a difference if, say, the court chooses to allow intervening of right as compared to permissive as to later requests for intervention? So if I'm not asking that quite succinctly enough, do you think there's a difference if I determine that, well, I'm going to allow permissive intervention? Would that have a different effect if there are later requests for intervention as compared to if I determine that the facts support an intervention of right? Do you think there's a different impact on potential other interveners?
I do, Your Honor. I believe that that there are specific standards for intervention as of right, and if they are met, then there isn't any discretion with the court. Obviously, that's the definition of it, and so the main argument I'm making is that Continental is precisely situated the same as all the other oil and gas operators in the state, and so if Continental is allowed to intervene as of right, there's no reason the rest of them shouldn't. The concern we have is that's also something that they can take an immediate appeal from if it were denied, for example. And I'm talking about other operators. And so that could significantly slow things down or grind the litigation to a halt. Whereas with permissive intervention, I don't think that the court is insulated from challenge to a decision. It's an abuse of discretion standard if that were to go up on appeal, but I do think that the court has greater latitude, for example, to deny intervention under the permissive intervention standard, the same as it has more discretion to allow intervention. And so I think that the concerns with opening the floodgates, so to speak, are much more striking and concerning with respect to granting Continental's motion to intervene as of right versus the permissive intervention.
Okay, thank you. And then just a couple more. The Planned Parenthood case, the Minnesota case you talked about, and I just want to make sure I understand your point. I just want to make sure I understand the facts because I did not read that case. I did certainly read the brief and the points made, but was that with the other property owners close to the proposed abortion clinic, and in that case were they granted intervention because of their property interest in the property in a similar location to the Planned Parenthood, or was that intervention denied? The first question. And the second of that is if you just speak to then if it was granted, the difference between their property rights in their individual property, and contrast that with the argument that Continental Resources has property rights in the subsurface or in the leasehold interests of this oil and gas. If you speak to those two things, please.
Sure, and I think that what the court in the Planned Parenthood case said is that the district court had erred in refusing to allow the applicants to intervene, and so it did allow them to intervene, and I believe that's why Continental is citing this case. My point was that makes sense in that context, and to your second question, in that case, I think that whether or not the legislation was upheld, I guess I can't give you all of the detail from the case to do it justice, but the point I'm making is that you have a lot of very specific factual circumstances in that case, such as the attorneys representing the governing body are also concerned about whether or not members of that governing body have personal liability, and they need to take that into account in the way that they're making their arguments in the case. And that is going to lead them perhaps to downplay certain arguments or not make certain arguments, whereas the interveners are going to make whatever arguments they can to try and uphold legislation that prevents these abortion clinics from coming into their neighborhood. With respect to their property interest, they're claiming that they have fee title to land. They're literally just talking about their homes and the impact to the property values on their homes if this specific Ford Parkway abortion clinic comes into their neighborhood. And I recognize that the regulations are a general regulation, similar to the regulation here, but the point I'm making is that in that case, there were a lot of very specific factual circumstances and individual concerns, both with respect to the attorneys representing the governing body and essentially having a potential conflict of interest, as well as the interveners attempting to protect something very specific. Now, I'm not saying that Continental doesn't have anything, a protectable interest in this litigation. What I am saying is that the only cognizable and discrete protectable interest is their desire to not pay surface owners for use of the pore space. And with respect to that cognizable discrete interest, they are perfectly aligned with the state because, as I said, that's the whole point of the law. That's exactly what the law accomplishes in its purpose. It's not an indirect effect of the law or anything like that. And so on that point, on that interest, Continental and the state are precisely on the same page.
Okay. Thank you. I appreciate the thoughts. And then finally, the last one I had, and it was more of maybe not at central issue, but you had expressed some concerns with requests for attorney's fees in Northwest Landowners being a small entity. And I'm just wondering, is there more than, are you basing those comments on more than just what has been pled in the answers in this matter? Is there something more than that? Because it seems to me that in looking at, say, the complaint, the requested attorney's fees, and virtually every complaint or answer there's requests for attorney's fees, and obviously, as you're aware, there are somewhat limited situations in which attorney's fees are actually awardable despite being pled out. So I'm just wondering if you're basing the concern about potential requests for attorney's fees, is that something more than just because it's in the answer or consequently in your complaint? I'm wondering if there's more behind that other than it being pled.
No, Your Honor. With respect to the request for attorney's fees by the two defendants, and it is specifically, and it's because they don't even qualify with, as allowed by law. It's just they're requesting attorney's fees, and I don't know what the basis is for that offhand. I don't think there is one, but I don't know, and so that was the basis for the concern, though.
Okay. All right. Thank you. Before I turn it back to Mr. Leggett, anything else, anything that my questions triggered that you weren't able to fully answer, Mr. Broughton?
I don't think so, Your Honor.
All right. And thank you. So then, Mr. Leggett, I will turn it back to you.
Thank you, Your Honor. I want to point out that the association is inviting you to create a new rule of decision, as I understand the argument that was just made, that is not to be found in any of the cases that have been cited to you. It appears that if we have a similar objective as the state of North Dakota, then that means it will adequately represent us. And even though the association has conceded on page 3 of its brief that we have interests that will be impacted by this litigation, it draws the distinction that we have the same impacts as other members of the oil and gas industry. That's not in the complaint. It's probably not even correct, but Your Honor certainly does not know that. More importantly, that's not the test. Test is whether Continental's interests are the same as the citizens of North Dakota generally. That is why I called the court's attention early to the Chiglo case. It's only if Continental's interests coincide with the public interest. There are a great many people in Bismarck who do not share Continental's interest in this litigation, but they presumably share in the interests of the state as a whole. So it's not that we have to have a unique right, far from it, The Planned Parenthood case that Your Honor asked about concerned an application for intervention by just two couples, the Lennons and the Vernigs. They were not the only property owners that were near the abortion facility. Their interest was not unique in the same way that our interest is not unique with maybe Hess or a couple of other companies. But our interests and our activities have been important enough for the association specifically to plead them in the complaint as part of their claim against the state. And again, the state is not going to share in Continental's second payment to a landowner for rights that we already own. So it's not protecting our right. It's protecting some broader interest, the view that the state is better off overall with a healthy, vibrant oil and gas industry, and the determination that this particular 2009 law was interfering with that broader goal. So we don't have to show a unique interest. All we have to show is that the state's interest is broader than our particular interest. And that particular interest, at least, has been conceded by the association under the interest prong. One other point I would like to make, actually two, but maybe the more important point is this. On page 7 of our reply brief, we call the court's attention to a 10th Circuit decision, Utah Association of Counties versus Clinton. And there, the government had taken no position on the intervener's efforts to intervene on the federal government's behalf. The court said, quote, "The government has taken no position on the motion to intervene in this case. Its silence on any intent to defend intervener's special interests is deafening." Quote. North Dakota is not represented to this court that it's going to look out for Continental's particular issues here in this legislation, and that silence here too, deafening. Finally, I'll call the court's attention once again back to the National Parks Conservation case. Same page citation, 759, F3rd, 977. The court spoke to two additional practical considerations for letting the private company in. The company is going to provide expertise on the issues in this dispute. Continental certainly will be able to advise the court about the nature of pore space and oil and gas operations. Second, the private company cannot be assured that EPA's current position will remain static or unaffected by policy shifts. This 2019 law could be changed again while this case is still pending, and in fact, even while it's being defended, there may be a change in administration that does not wish to defend the current bill. So Continental has to be allowed in to protect against that chance. Your Honor has no further questions. I'll rest on the briefs.
All right, I don't think I do, actually. So I appreciate the arguments. I appreciate, arguments from both sides. It certainly has nice to understand a little bit more the thought process behind the briefs. So with regard to that, then I am going to take this under advisement. I have things to think about, obviously, and factors to weigh in making my decision. So I will be issuing a decision with regard to this, and I will attempt to get that out here before too long passes, so the parties are all aware of the state of this case. So if there is nothing else, well, let me just ask if there are any questions before we wrap this up. So first of all, let me just ask, as far as from Northwest Landowners, Mr. Broughton, any questions at all about? I don't want to give a definite timeline, but I do want to get an order out here within a reasonable time. Any questions or anything else to address before we adjourn for today?
No, thank you, Your Honor.
Okay. Mr. Leggett, anything else? Any questions at all before we are done?
Nothing further, Your Honor. Thank you.
All right, thank you. And then Mr. Sagsveen or Ms. Meyer, any questions at all?
No, Your Honor, there's no questions relating to the motion.
All right.
No, Your Honor.
Very good. Then, as I indicated, I do appreciate everybody appearing and attending today, and I will take this matter under advisement and issue a decision here in the hopefully near future. If that is everything, we are adjourned, and I hope you all have a safe and healthy remainder of the day, and we will go ahead and disconnect now. So thank you all for appearing.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.